Hello everyone and welcome to part 12, the last part of Polity Premier League 2025. Let's begin. First question. Consider the following statements regarding the President of India. The President can return a bill of a state legislature for reconsideration by the state if it is not a money bill. Yes, of course. When it is reserved for her consideration by the governor. Yes. In the recently concluded Governor of Tamil Nadu versus the Government of Tamil Nadu, the Supreme Court clarified that the President can return a bill of the state legislature if it has been referred by the Governor. However, the President must take an action within 3 months. Okay, so one is correct. Second statement. If the state legislature repasses the bill with or without changes and sends it again, the President is not bound to give assent to the bill. Absolutely correct. There is no such mandate for the President to sign. However, if the Governor uses this concept of suspensive veto, meaning sending the bill back, withholding the assent, and if the state legislature repasses the bill, the governor is bound to sign the bill within 1 month. But there is no such limitation on the Indian President. Number 3. The President cannot withhold assent to constitution amendment bills passed by the Parliament. Yes, the President has no authority to refuse to give assent to such bills when they are given to him for his assent or signature. Please tell me in the comment section which is the amendment act which has made it obligatory for the President to give assent to constitutional amendment bills under Article 368. Anyway, this is also correct. Right answer is what? Right answer is D, 1, 2 and 3. Moving on to the next question. Consider the following statements about the Union Council of Ministers. The total number of ministers in the Union Council of Ministers, including the Prime Minister, cannot exceed 15% of total number of members of the Lok Sabha. Yes, this is absolutely correct. This change was made through the 91st Amendment Act of the year 2003. Number 2. A person may be appointed a union minister without being a member of parliament, but he or she cannot continue as a minister for more than 6 months unless he becomes a member of either house. Yes, correct. This is Article 75 Clause 5 for the centre or Article 164 Clause 4 for the states, the Nayak article, one day CM concept. So 2 is also correct. Number 3, the salaries and allowances of union ministers are specified in the 3rd schedule is wrong. Firstly, 3rd schedule refers to what? It refers to the oath and affirmation of our ministers, not salaries. Salaries are mentioned in Schedule 2 and the salaries of certain categories of people are mentioned like the President, like the Governor, the presiding and the deputy presiding officers, the Supreme Court judges and the High Court judges along with the CAG, the Comptroller and Auditor General. So 3 is wrong. What's the right answer? Right answer is A, 1 and 2 only. Next question. Consider the following statements regarding the 106th Constitutional Amendment Act 2003. So it provides for 1/3 reservation of seats for women in the Lok Sabha and in all state legislative assemblies. Absolutely correct. The first point is correct. The reservation of seats for women under this amendment took effect from 2024 general elections immediately after the law was enacted. This is wrong. This reservation will come into effect after the first census is conducted after the passage of this particular act. So 2 is wrong. Third one, the amendment did not require ratification by half of the state legislatures as it did not affect the federal structure or the representation of states in the parliament is absolutely correct. In this case, the right answer is what? C, 1 and 3 only. Next question. Consider the following statements about the ADL, anti-defection law in India. The anti-defection provisions are contained in the 10th schedule. Yes, 10th schedule contains the provisions for anti-defection law. Number 2. A member of parliament, an MP, is subject to disqualification under the law if he or she voluntarily gives up membership of the party or if he or she votes contrary to the party's official whip in the legislature. This point is also correct. As long as the party forgives them, they will not be disqualified. Otherwise, they are subject to disqualification. Number 3. The authority for deciding disqualifications of MPs under 10th schedule is the president is wrong. The deciding authority is the presiding officer of the respective houses, be it the Lok Sabha or the Rajya Sabha. The president and governors will look into disqualifications on other matters, like those matters which are mentioned under Article 102, Clause 1. Things like not being a citizen of the country, things like if you have become bankrupt or unsound mind or possibly office of profit. Okay, so this is where the president or the governor gets the authority. Of course, that is not their discretion. It is exercised on the advice of the Election Commission of India. So 3 is incorrect. This means that the right answer is A, 1 and 2 only. Next question. A no confidence motion against the Union Council of Ministers can be introduced in where? An NCM. Under which rule? Under Rule 198 of the Lok Sabha rules, can be introduced only in the Lok Sabha, not in the Rajya Sabha. Why? Because the Council of Ministers are collectively responsible to the House of the People, that is Lok Sabha. Right answer is A. Next question. Consider the following statements with reference to the basic structure doctrine. The basic structure doctrine was first propounded by Supreme Court in the Golaknath case 1967. This is wrong, of course. The basic structure doctrine, as we all know, was first propounded in the Case 1 and the Bharti case of 1973. In fact, the origin of this concept roughly comes from not this judgment but a different case called Sajjan Singh case. So in the Sajjan Singh judgment versus the state of Rajasthan, the Supreme Court did actually, not the Supreme Court, but one judge, Justice Raghunath Mudholkar, he raised this very interesting concern. The concern that we cannot let the parliament have arbitrary, unfettered, unlimited power to modify the constitution. This can be seen as a source possibly for the basic structure, laying the groundwork for basic structure. However, it was in the Case 1 and the Bharti that this concept was first propounded. So 1 is incorrect. It holds that certain fundamental features of the Constitution cannot be altered or destroyed by any amendment is correct. And number 3, the term basic structure is explicitly defined in the Constitution. There is no such definition of basic structure. The source is not the Indian Constitution, but it is a judicial innovation, right? So 3 is wrong, 1 is wrong. Which statements are incorrect? 1 and 3. The answer is C. Next question. In March 2023, the Supreme Court of India ruled on the appointment process of the CEC and election commissioners. According to this judgment, until Parliament makes a law on the subject, the CEC and ECs shall be appointed by. So, in this Anup Barnwal case of 2023, the Supreme Court in its judgment said that the CEC and ECs, to ensure their independence, of course, must be appointed by the President on the recommendation of a committee comprising of the Prime Minister, the Chief Justice of India himself or herself, and the LOP in the Lok Sabha. So B is the answer, and then the Parliament made a law and replaced the Chief Justice with the Union Cabinet Minister. Anyway, so right answer is B. Next question. Consider the following statements about the Citizenship Amendment Act 2019. The CAA allows Hindus, Sikh, Buddhists, Jains, Parsis and Christians from Pakistan, Bangladesh, Afghanistan who entered India by December 31st, 2014 to apply for Indian citizenship. Yes, they will no longer be deemed to be what? They will no longer be considered illegal migrants. This means that now they become eligible to apply for Indian citizenship, because as you're aware, illegal migrants are not allowed to apply for citizenship under processes or systems like registration or naturalization. Under which law? The Citizenship Act of the year 1955. So one is correct. The CAA extends the same eligibility for fast-track citizenship to Muslim immigrants from these specified countries. No, the Muslim and other religious communities barring these 6 have been excluded from getting the benefit under this law. 2 is wrong. The provisions of CAA shall come into force immediately after the first census is conducted after the passage of this act. No, there is no such foundation, there is no such impediment or obstruction or no condition that we need to conduct a census for it to come into force. The law came into force. However, of course, the application of it depended on the rules to be framed by the government, and in 2024 the rules were framed and then the law could come into force properly. It was implemented to provide benefits to certain categories of people. So 2 and 3 are wrong, which statements are incorrect. Right answer is B, 2 and 3. Next question. How many UTs in India have their own elected legislative assembly and council of ministers? So the UTs of course, Delhi, Puducherry and Jammu and Kashmir. 3. These 3 UTs have legislative assemblies. Other UTs do not have an assembly. They have an administrator. So right answer is B. Next question. Consider the following statements regarding local self-government in India. The SEC, the State Election Commission, is responsible for conducting elections to panchayats and municipalities. Yes, the ECI has no role to play here. It is the State Election Commission, a constitutional body headed by State Election Commissioner. Article 243, capital K. This person is appointed by the governor and can be removed only in the same manner, same grounds as a High Court judge. So 1 is correct. Second one, according to the constitution, the minimum age to contest for panchayat elections is 25 years. So the minimum age to contest for Lok Sabha or for legislative assembly is how much? Is of course 25. But for panchayats, the minimum age to contest is 21 years and not 25. 2 is wrong. So A1 only is the right answer. Next question. Consider the following statements about the 10% EWS reservation in India. The EWS reservation was introduced by the 103rd Constitutional Amendment Act 2019, providing 10% reservation in education and public employment for economically weaker sections of citizens who are not covered by any other reservation. Yes, absolutely correct. The EWS quota applies to persons from all communities, including those belonging to SC, ST and OBC categories. Of course not. It is only for people who are otherwise not covered under other reservations. So SC, STs are not covered, right? So of course 2 is incorrect. Now, which statement is correct? Right answer is A1 only. Next question. Consider the following statements about the status of sedition law, section 124 capital A. So this was under the IPC back in 1870. This section was introduced to curb any kind of dissent against the then government. And the recent developments. So in 2022, the Supreme Court effectively suspended the operation of sedition law by directing that no new cases should be filed under section 124 capital A IPC and ongoing cases be put on hold pending a review of the law. Absolutely correct. SG Wombard-Kere case, Supreme Court came down heavily on the misuse of sedition and said that from now on no new cases will be filed until the government revisits on the constitutional validity of such an extremely harsh law. But then, second point, BNS 2023, which has replaced what? It has replaced IPC, the Bharatiya Nyaya Sanhita, omits the offense of sedition, removing section 124A and replacing it with provisions targeting acts against the sovereignty of India. Yes. So now we do not have any law which is anti-government, but rather the focus is now on the nation. So anti-national in true sense. So yes, sedition as a law is no longer available, does not exist under BNS 2023. So in this situation, 2 is also correct, which means C, both 1 and 2 are correct. Next question. Consider the following statements regarding the directive principles of state policy in the Indian Constitution. The Constitution explicitly directs the state to establish a uniform civil code for citizens as a DPSP. Yes. This is which article? Article 44. Number 2. The DPSPs are non-justiciable, meaning they are not enforceable by any court for their violation. Of course, this is also correct. This is clearly mentioned under Article 37 that they are non-justiciable. However, they are fundamental in the governance of the country, and it shall be the duty of the state to ensure that these principles are used, incorporated while deciding policies, making laws in the country. Number 3. In case of a direct conflict between a DPSP and fundamental rights, the fundamental right will always prevail is wrong. I hope you know Article 31 capital C, which clearly says that in pursuance of DPSP 39B or 39C, in case the law violates Article 14 or 19, the law will still prevail. Why? Because the purpose is to achieve the objectives of 39B and C, that is to distribute the country's resources amongst everybody and also to reduce the concentration of wealth. So 3 is wrong. Which statement is incorrect? Right answer is C, 3 only. The next question then is on preamble. Consider the following statements about the preamble of the Indian Constitution. The preamble is a part of the Constitution. Yes, Keshwanan Bharati 1973. Preamble is a part of the Indian Constitution and can be amended under Article 368. Yes, preamble has been amended once by adding certain words. Number 2, the preamble was amended once to add the word socialist, to add the word secular, as well as integrity. All 3 are correct to the original text. Number 3, the preamble declares India to be a federal state by using the term Federation of States. There is no use of such a term in the preamble, hence 3 is wrong. Right answer A, 1 and 2. And the last question of this series, which of the following bodies was established by a constitutional amendment to promote cooperative federalism in India? Niti Aayog. Of course, Niti Aayog does promote cooperation as well as competition, but this is an executive body. Interstate Council is a body established in 1990 by the President under the direction of Article 263. Finance Commission is already a constitutional body under Article 280. So the right answer is GST Council, C. This brings us to an end of our discussion on this series. I hope the series was helpful to you, and let's hope that some of our students, our innocent aspirants, do make it to the list. Now, I say some because, of course, it cannot be all the students. So I would hope that all my students clear the exam and become rankers, but that would be too sentimental, too emotional, too far-fetched, right? So let's meet in some other video. Till then, that is all for me. Jai Hind.